I'm here today with Mr. Deans, who's a patent attorney. Mr. Deans, please can you tell us about the work that patent attorneys do?
We protect an invention. If people make an invention, we protect that by means of a patent application. We protect the brand names that they use in their business by registering them as trademarks. And we protect the appearance of any product that's produced by way of design protection, which comes in several different varieties, some of which are free and some of which you have to pay for, and of course get enhanced rights.
What sort of clients do you work for?
Virtually anybody who makes inventions, right from a single individual who may have a good idea in his garage, right up to multi-million-pound organisations.
So, what are the different types of intellectual property?
Right. Well, intellectual property does come in quite a few different kinds. The first one, which every client has when they come to me, is trade secret. Trade secret is a kind of intellectual property, but it's one which wastes away because the moment you let the secret out, it's gone. It no longer has a value after that. And the point about the other types of intellectual property are that they help to protect that secret beyond the point where you disclose it. Now, of the different types of intellectual property, the simplest is copyright. Every time you write or draw anything, that automatically creates copyright. And automatic is a lovely word. In intellectual property terms, it means it comes for free. You don't have to do anything, you just have it, provided you've got the paperwork to show how you actually got to the piece of writing or the drawing. But copyright does not protect the ideas which are expressed in the piece of writing, and it doesn't protect what's actually illustrated in the drawing. It just protects the drawing itself. So you need to have some other kinds of intellectual property as well. The first one up the list from copyright is design right, more correctly called unregistered design right, because you don't have to register it. Like copyright, it's automatic, it comes for free. Whenever the design of anything is fixed in a design document, which is a fairly loose term that not only includes paper but includes photographs, film, even a prototype. If you stick a luggage label on it, that is a design document and it fixes the design of the product. So design right protects the appearance of the product. Only its appearance, not what it does, merely what it looks like. And it does it for free. It protects against literal copying of that article when it's out on the market. But it's only a short-lived right. It only lasts for 10 years maximum, and after the first 5 years have gone by, anybody can come along and ask for a licence and you can't say no. If you want more sophisticated protection for the appearance of something, then what you do is register it as a registered design. That also protects the appearance, the aesthetics, what it looks like, not what it does. But it doesn't depend on someone having copied you to be able to stop them. If they merely come up with something that looks roughly similar, it's likely to be an infringement of the appearance. And the other type of intellectual property, besides patents, which are often regarded as the king of intellectual property, there's also trademarks. The name that you use can often be the most important thing in your whole arsenal of intellectual property rights, because it's what brings the customer to you, it's what they pick up the phone and ask for. And we also protect brand names as well.
If I'm seeking then to register a trademark, how would I go about that in partnership with you?
Well, you tell me what the trademark is. We can have a quick check to make sure that nobody else has got there first. I'm afraid it does sometimes happen. And if it looks as though someone has rights there which your use is going to infringe, then we'll suggest to you at that stage, before you're absolutely wedded to the name and can't readily change it without a lot of cost, that you should think about something else at that point. Having checked that it's not actually there, we would check normally both the British and the European Community registers in one go. It's fairly easy to do. Assuming that it isn't there, then we'll file an application for you, having established what are the particular goods and particular services that you are trading in or intending to trade in over, say, the next 5 years.
How long does that trademark process take?
It's remarkably quick these days. The British Trademarks Registry, part of the UK Intellectual Property Office, is very efficient. And assuming there are no problems, we will know within weeks whether the mark is likely to go through to registration or not.
Do you know whether that's similar in the United States as well?
In the United States, it's much more drawn out. It's also more difficult to do the searching right, and probably more important to do the searching. Because in the United States, it happens to some extent in this country too, but in the United States, trademark rights depend a great deal on use, and therefore people may have trademark rights without ever having registered them. And therefore it is important to do some sort of searching, what we call a common law search, a search to see what is actually out there being used before you commit yourself to a trademark.
How long after a design is disclosed can you file?
Design protection is unusual in that, unlike a patent, which has to be filed before it's disclosed, absolutely crucial it's filed before it's disclosed, in the case of protection for the appearance of an article, design protection, you can actually validly file a design application in the United Kingdom or in Europe up to 1 year after it's first been disclosed. In effect, what this means is that you can file your patent application to protect the underlying idea, how your product works, how your product is constructed, and then you can do the final design on the product, how it finally looks when it gets out on the market. You can touch that up, you can make changes in it up to 1 year, and then register the design if you find that it's worthwhile and it's selling.
I guess you would suggest that either a confidentiality or sometimes known as a non-disclosure agreement would be very important at the very early stages before you have any protection in place?
Such agreements are useful in concentrating the minds of the people you're talking to, but they aren't actually necessary in law. If something is disclosed in confidence, then it is disclosed in confidence and it is confidential, and the person to whom it's disclosed does not have the right to disclose it any further. And something is confidential if you tell them it's confidential when you disclose it, or if the circumstances under which it is disclosed are such that you would have expected it to be confidential. You don't actually need such agreements. But such agreements are a good idea because they help to establish clearly in writing where everybody stands.
Early in the process, it is important that people get to somebody like yourself and talk to them about trademarks, talk to them about patents and all the other issues that we discussed today, because these are the foundations that they would build their business on.
Oh yes. I'm afraid I occasionally see people who I tell them, well, you really should have come and seen me 6 months ago, it's now too late. And that is really sad when someone comes to you with what is a really cracking idea and you can't any longer get them protection for the underlying idea because they've disclosed it freely or perhaps even sold one. They say, well, what's the idea? It's not worth filing a patent application until I know I'm actually going to make some money. I'm afraid you can't do it that way around. It has to be done the other way. For patents, it's crucial. It's the key rule of patents. File first, disclose later.
As a new inventor, when would I choose to come and discuss my invention with you?
Well, that can vary. It varies for different inventions. The important thing is that you should come and talk to a patent attorney before you disclose it publicly. Now, it's all right if you disclose it in confidence. That's fine. You can talk to quite a few people in confidence, but don't make it too many, or there's always a risk it may leak out. But certainly before you get to the stage of manufacture, and certainly long before you get to the stage of selling it.